Welcome to Hull on Estate and Succession Planning, a series of podcasts hosted by Ian Hull and Suzana Popovic-Montag that will provide information and insights into estate planning in Canada from the offices of Hull Estate Mediation in Toronto. Here are Ian and Suzana.
Hi, and welcome to Hull on Estate and Succession Planning. We're listening to episode 138 of our podcast on Tuesday, November 11th, 2008.
Hi, Suzana.
Hi there, Ian. Happy Remembrance Day.
Yes, it's a big day. I forgot to wear my poppy for the podcast, which is a bit embarrassing, but it is up in my office. I just moved too quickly. Why don't we, first of all, remind everyone, please feel free to give us a call at 206-457-1985.
Or leave us an email at hullandhull@gmail.com with any comments or questions that you might have that you'd like us to address during the course of our podcast.
Now, one of the things that we have been able to explore in our series on testamentary capacity were the 5 factors that the court looks at when challenging a will. And they are, of course, lack of testamentary capacity, undue influence, due execution or properly executing a will, suspicious circumstances, and fraud. So why don't we start to talk a little bit about some of those issues, each one of those issues in some detail. Let's start with the question of capacity. That being what? To know and understand the nature and effect of your dispositions and to understand who your rightful heirs or dependents would be.
And the test for whether or not someone has legal capacity is a very old one, as you know, and it arose in the case of Banks and Goodfellow many, many years ago. And it still is the litmus test for when judges are determining whether or not someone actually had the requisite capacity at the time that he or she executed their last will and testament.
And the thing about a will challenge that is seems a bit unconventional is that the person who is essentially the plaintiff or the active party at a trial is actually the person who is propounding the last will, the one who's pushing forward the last will. You'd think naturally that if you're attacking a will, that you're the active participant attacking the will, but as it turns out, the law that developed back in the 1870s and since has made it clear that indeed the person who holds the last will is the one who must prove that it is the last valid will of the deceased.
And when you say holds, Ian, you mean the person who is named as the executor of the will or the executor of the estate. It's that individual who has the obligation to put forward the document and say, yes, this is the last valid will and testament?
That's right. And really, when we look at this, though, it's the whole question still centers around the last person standing. And so whenever you make an application for probate in Ontario, for example, you have to tick off a box, if it's not contested, that says, are there any other testamentary documents? And any other prior, subsequent testamentary documents. And so you have to make sure that the search has been done to get to the last will. But so once you've got this will in hand and you're obligated to propound it in this lawsuit, it changes a lot of the effort that one undertakes to pursue a will challenge, because you have to appreciate right from the get-go who has onuses and who has to do what.
And the truth is, when you're named an executor of a estate, you're making these searches, you're usually going to find out either directly from someone right at the get-go that they're going to have a problem with whatever document is found to be the last will and testament, or you're actually surprised when you go to file the application for probate and you find out that the court registrar won't accept it because someone has already filed an objection on some basis to the will itself.
So when we're commencing a will challenge, it can be done several ways, but one of the ways is essentially, like you say, you file this notice of objection with the court. But let's talk a little bit about, once we get through the preliminaries, because each province has their own sort of unique steps at the outset. But essentially, we used to call it a caveat, whatever you want to do. You file with the court saying you're challenging the will. The first step that you'll typically find is that the parties will want to set out what the issues are. And there are 2 ways to do that. One way is in a straightforward one-sentence approach, which is set out in the order for directions at the outset. Or another way is that parties will actually change and exchange pleadings. Like they will set out the writ like you'd see on TV. You'd set out the nature of the claim like a statement of claim. And we find 6 1/2 dozen the other. It doesn't make a lot of a difference, but it just seems more efficient to just set out the issue as being the son challenges the validity of the will and on the basis of lack of testamentary capacity or something like that, as opposed to telling the whole story of the son and the daughter and the mother and who was saying what and so on, because that story eventually comes out. And it seems like sort of an extra step at the outset, but as I say, it's either way. But you commence it either by an order for directions or order for directions that includes a statement of claim.
And of course, also a statement of defense for the individual who's defending whatever allegations are being made, setting out their side of the story. And as you say, these stories tend to come out anyways during the whole process, and it's just where I think the individuals who are retained to commence and to defend these proceedings, where their comfort level is, because the same kind of information will ultimately come out. It's just a question of when.
That's right. So once you've decided whether you're going to commence it, how you're going to commence it, the will challenge itself is focused on that preliminary question of lack of testamentary capacity. And we've talked about how we will go and chase down evidence to determine it through medical records, through lawyers' efforts, and all of that. But it always helps to go back to fundamentals as to what the concept means and what the term means. The next sort of core issue that is considered whenever you challenge a will is the question of undue influence. And we've already defined that in our past podcast, but essentially it's coercion. It's where someone forces the other person to act in a way that is unnatural in that sense.
And unexpected too, in a way. And the one interesting thing about claims of undue influence is the fact that it will actually change the onus, or who's required to prove what, when you're making that kind of allegation. And as you said earlier, when someone is challenging a will, then the executor or whoever is actually charged with propounding or upholding the will has the obligation to defend it against that. But if you're making an allegation of undue influence, then you suddenly have the onus. That individual has to prove that in fact the deceased was being unduly influenced. And I know onus is a legal term, but it's sort of, who has to prove what and at what point in time, or who has to lead the evidence. And an allegation of undue influence is the person who's saying, yes, arms were being twisted, the individual didn't know or didn't appreciate or couldn't have wanted that because they were being coerced.
And as long as that coercion is proven by corroborative evidence, it's a pretty compelling claim.
That's for sure.
And it can again be set out by way of the order for directions or the more comprehensive pleadings, statement of claim, statement of defense.
That's right.
And it is so important to determine who's plaintiff and who's defendant, and sometimes it gets a little awkward when you're doing the pleadings on the question of undue influence, and as a result, the practice has been to move away from the pleadings a little bit because it actually complicates matters. Are you a defendant or a plaintiff on the question of undue influence? So it really, and it can be overcome, but it can be something that is easily avoided if you just simply stay with the straightforward, the son alleges undue influence, the daughter denies that there's undue influence. All right, well, those are the two central issues in a will challenge, and we'll proceed along and finish up with the next three in our next podcast. Please, again, feel free to send us a email comment or any questions you may have at hullandhull@gmail.com.
And of course, you can feel free to call us at 206-457-1985. Thanks very much, Ian.
Thanks, Suzanne. That's great.
You've been listening to Hull on Estate and Succession Planning with Ian Hull and Suzana Popovic-Montag. The podcast you've been listening to has been provided as an information service. It is a summary of current legal issues in estates and estate planning. It is not legal advice, and you are reminded to always talk with a legal professional regarding your specific circumstances. To listen to other Hull On podcasts or to leave any questions or comments, please visit our website at hullestatemediation.com.